In fact, under Admiral Dalton's testimony, you communicated through General Myers that she should cease her formal analysis in response to these concerns. Is that accurate?
Well, I have the highest regard for Admiral Dalton, and I'm sure whatever she said is accurate to the best of her recollection. I don't have perfect recollection of that time, but I accept her word. There's no question. But let me finish, Senator, because you say I acted in a vacuum. That's absolutely not true. I looked at this hard. There was a you know the Defense Department. You're a West Point graduate. You're a Harvard-trained lawyer. You're a fantastic senator, and I have the highest regard for you. But you know how that place works. I mean, there are thousands and thousands and thousands of decisions made every day. This was one. It was an important one, but it was one, and it came in the context that I described a moment ago with an extraordinary degree of urgency. My client, my boss, the Secretary of Defense, needed a recommendation. It had been sitting in the headquarters for a month when the Secretary of Defense said, "I need a recommendation to his senior advisors, me, the Chairman of the Joint Chiefs, the Deputy Secretary of Defense, the Undersecretary of Policy, and others who met with him every day. I need a recommendation." I took it. I looked at it. I looked at the package. I looked at the circumstances. I made a legal judgment. I consulted with Captain Dalton during that time. Her testimony reminds me of the care with which we dealt with it, and I rendered my opinion.
But it doesn't remind you of whether or not you told her to cease her formal analysis.
I don't remember that specifically, but Senator, let me say it makes sense to me, even in this remote time, because there are 10,000 lawyers in the Defense Department. There has been a portrayal of this event in the press and in today's hearing by some people as if the military lawyers all objected and the civilians or somebody just ignored them. There were military lawyers whose job it was to advise those people in that chain of command, the commander at Gitmo, the commander of Southern Command, the chairman's lawyer, and then me for the Secretary of Defense. And the testimony earlier mentioned that the Central or the Southern Command lawyer was perhaps not as involved as he might have been, but the other three people in the chain of command whose job it was to advise those leaders looked at it carefully, looked at it under the circumstances. There is a paucity of law that was applicable at the time, and my job as the lawyer is not just to say no, but to say where is the area of discretion available to the client, in this case the Secretary of Defense. And that was my determination, and I stand by it.
What did you rely upon? What legal analysis specifically? Not your just thinking internally about these great issues.
Well, I'll try to go through it with you right now. The U.S. Constitution, we believed, under the Eisentrager case, did not apply at Guantanamo. The President had already determined that the Geneva Conventions did not apply to the Al-Qaeda detainees or the Taliban detainees. The Convention Against Torture would apply, but it's a non-self-executing treaty. The implementation of that was the statute passed by the Congress of the United States and signed by the President. So the prohibition against torture reflected in that statute applied, and the Article 16 of the Convention Against Torture prohibiting or imposing on the United States an undertaking to prohibit cruel, inhuman, and degrading treatment was applicable. The President's order to treat detainees humanely was a restriction, and in the application of and the Uniform Code of Military Justice to some degree would apply as well. And the application of those strictures to this circumstance under the operating procedures that all of the decision makers and advisors understood to be applicable led me to believe that the Secretary had the discretion to authorize the techniques that we recommended.
If the Uniform Code of Military Justice applied, do you agree with Colonel Beaver's analysis that it would be a per se violation of 128, Article 128, to engage in the poking and light pushing?
I did not think so.
Did you make that any clarification why you didn't agree with
it? Well, I didn't write a memorandum to that effect.
Did you write any memorandums to this effect?
I wrote the memorandum that you have in front of you, and that was actually more expansive than the General Counsel of the Department of Defense usually does in decision-making for packages going to the Secretary of Defense.
How did you communicate this decision to Southcom and to Guantanamo? Did you send them a copy of the memorandum?
I did not. And I think it's important also to note, Senator, I'm sure you'll appreciate this, as the lawyer, I was not the decision-maker. I was an advisor. The Secretary of Defense made the decision, based in part on my advice as well as the Chairman of the Joint Chiefs' advice. And the normal transmittal of a decision of that nature would be through the joint staff, and I would assume that's how it was passed.
So once the Secretary signed off on it, you had no follow-up on this at all? You don't know how it was communicated?
Well, I would think it was communicated in the normal fashion.
Was this memorandum sent down to
Senator, I don't, I mean,
you don't know.
I don't. That's
Admiral Dalton went to great length to say that her recommendation to you, her concurrence, was based upon the conditions that would govern the use of these techniques. Can you point to the conditions how were these conditions communicated by the Secretary of Defense, and where are they reflected in your memo?
Well, they're not in my memo, but as I told you, most decision documents that would go to the Secretary of Defense would, I wouldn't write, nor would most of the other staff people who would sign on a block would not write extensive.
But if those conditions
don't do that.
If those conditions were central to the legality of your advice, wouldn't you have a legal obligation to make the Secretary aware of them? And this goes to a more fundamental. Did you tell the Secretary how difficult and close a call this was?
Oh. And
how that there were significant adverse conclusions by subordinates, and that if you follow Admiral Dalton's logic, that his concurrence would require significant conditions that he also must approve, or at least be aware of?
Well, Senator, you're assuming something that's not so. You're assuming that there were no understood conditions.
But understood by who?
Understood by everybody involved in the process. People who were knowledgeable about the proposal and how it would be applied all understood what was meant by the proposal. Captain Dalton talked at length about that in the earlier panel, and I don't know if you were here to listen to it. But
could you list the conditions that were applicable? Could you list the conditions that an interrogator had to follow?
Could I list them?
Yes. Well, everyone understood them. Well, they were clear to the interrogators, clear to everyone else.
Senator, you've probably got access to more documents than I do.
No, I'm asking you, can you list the conditions? I'd like you to answer the question.
Let me finish. I'd say you've got more documents than I've ever seen on this, and you will have in the documents that you've got the standard operating procedures, the people assigned to monitor. You had testimony earlier. There were interrogation plans that were supposed to be designed for each individual detainee who was to be interrogated, that would involve a psychological review. There had to be medical care associated with it. There had to be a legal review. There had to be substantial command monitoring. There was a step process that they were supposed to go through. They were supposed to stop if anything came up. There were all sorts of conditions, and not to mention, Senator,
where in this memorandum is to reference those conditions?
Not to mention, as you know, the training and the quality of the soldiers that I think these questions malign.
I object strenuously to that. You did a service to the soldiers of this nation. You empowered them to violate basic conditions which every soldier respects: the Uniform Code of Justice, the Geneva Convention. Here's what soldiers do. You said the Geneva Convention doesn't apply, and they honestly asked, what does apply? And the only thing you sent them was, these techniques apply. No conditions, nothing. So don't go around with this attitude of you're protecting the integrity of the military. You degraded the integrity of the United States military. And I finished my question.
Well, Senator, I object to that, and I disagree with that. And I would also point out that the President of the United States, with advice of the entire Cabinet, made the determination about the applicability of the Geneva Conventions.
Senator Sessions. Thank you, Mr. Haynes, and thank you for your service. You've served your country in uniform. I know your son is an ROTC now and seeking to be a military officer, and I know you love and respect the military, and I know that you care about getting this matter right.